Hello, good afternoon everyone. Pauline and I are going to be talking to you about the Corporate Insolvency and Governance Bill 2020. One thing to note just before we kick off is that the bill was actually given a royal assent on the 25th of June and came into force on the 26th of June. So we're now talking about the Corporate Insolvency and Governance Act 2020. What the Act seeks to do is put measures in place to relieve the burden on businesses during the coronavirus outbreak. It does this in a number of ways, some of which we'll cover off for you this afternoon, and we'll consider the new moratorium, prohibition of termination clauses, the new restructuring plan, flexibility to meet the demands of COVID-19, personal liability for wrongful trading, and the easing of certain deadlines and flexibility in relation to the Companies House. It's a very broad topic. We've got an hour this afternoon, and we're hoping there's going to be some time for questions throughout and towards the end. If you just use the Q&A box, which is in the bottom of your screen there, because we could spend half a day or a day talking about this, any questions that we don't get a chance to run through this afternoon, we will come back to you on after the webinar, and obviously you've got our contact details and you can get in touch with any specific questions you have. We'll be looking at both the permanent and temporary changes that have come into force now. In a lot of instances, we're yet to see how these are going to play out, and a lot of it, we'll have to see. Time will tell. I'll hand over to Pauline now, who is going to tell you more about the new moratorium.
Thank you, Michael. Well, good morning all, and thank you for tuning in with us today. So as Michael said, I'm going to talk to you about the freestanding moratorium. So the Act introduces a new standalone moratorium procedure for companies, which is a director-led process, and in effect leaves the directors in situ to continue to trade the company with an IP acting in the role of monitor, overseeing the company's affairs. As we all know, the aim of all of this is to afford companies some breathing space from creditor action to formulate a turnaround plan without adding significant cost to the process. The moratorium is completely focused on the recovery of the company rather than the realisation of its assets. The moratorium itself initially provides the company with 20 business days protection from certain creditor action. It can, however, be extended, and I will explain that in a bit more further detail later on. Early termination of the moratorium is also possible. The moratorium is broadly similar to the administration moratorium, which I'm sure we're all familiar with, and includes restrictions on insolvency proceedings, enforcement of security and forfeiture. The monitor must be throughout the moratorium and, like I say, continue to remain of the view that rescue of the company will be possible. If the monitor at any point is no longer of the view that rescue is possible, then the moratorium must end. During the moratorium itself, the company must continue to pay certain debts, including newly incurred liabilities, payments for new supplies, rent in respect of the moratorium period itself, certain payments due to employees, and debts under financial contracts, including lending contracts. If those debts aren't paid, the moratorium will end. Therefore, support from lenders will be required throughout this process. The Act divides the company's debts into three categories. We've got pre-moratorium debts for which the company has a payment holiday, pre-moratorium debts for which the company does not have a payment holiday, and moratorium debts. The significance of these is that the company must continue to pay pre-moratorium debts without a payment holiday and moratorium debts during the moratorium, but it is severely restricted in its ability to pay pre-moratorium debts with a payment holiday. Those owed pre-moratorium debts with a payment holiday are not able to get court permission to enforce security in respect of those debts. So what is a pre-moratorium debt? A pre-moratorium debt is essentially a debt that existed before the moratorium began, or a debt which did not itself exist before the moratorium began, but where the obligation under which the company later becomes liable to pay that debt did exist. So what are pre-moratorium debts with and without a payment holiday? Pre-moratorium debts are divided into those with a payment holiday and those without a payment holiday. Pre-moratorium debts without a payment holiday are those debts which have fallen due before the moratorium or which fall due during the moratorium, and which are amounts payable in respect of, firstly, the monitor's remuneration and expenses, goods and services supplied during the moratorium itself, wages or salary arising under a contract of employment, redundancy payments, rent payable in respect of the period of the moratorium, and debts or other liabilities arising under a contract or other instrument, including financial services, which includes, for the avoidance of doubt, a loan agreement. So what's a moratorium debt? A moratorium debt is essentially a new debt arising during the moratorium itself, or a debt which might arise after the moratorium, but due to an obligation that was incurred during the moratorium period. Given that financial debts and liabilities are classed as pre-moratorium debts without a payment holiday, and it is a condition of the moratorium continuing that such debts continue to be paid, it will be possible for lenders who do not support the moratorium to bring it to an end. They can do that by exercising their rights to accelerate payments due under lending arrangements and call for all sums due thereunder to be repaid. So this would almost certainly mean that any already distressed company is unable to pay and therefore would force the monitor to terminate the moratorium. Lenders might also then be able to benefit from enhanced rights. There was, however, considerable concern surrounding this when the bill was first presented, as it effectively gave lenders A, a power to bring the moratorium to an end, and B, provided them with almost a fixed charge like security for accelerated debt. Therefore, amendment was made within the Act to remove this, but it was not accepted, therefore they can, but it was accepted, apologies, therefore they can accelerate that debt. But one amendment was that was accepted was to remove the priority of the accelerated debt if the company enters into liquidation or administration within 12 weeks following the end of the moratorium, therefore removing that right for them to have a fixed charge like security. In terms of eligibility, generally companies are eligible to use the moratorium if they are incorporated under the Companies Act 2006. The directors state that the company is or is likely to become unable to pay its debts, and the monitor is of the view, again, that it is likely that a moratorium would result in the rescue of the company as a going concern. It's not clear just yet exactly how much work the monitor is expected to undertake to form the view that the moratorium is likely to result in the rescue of the company as a going concern. And as Michael said, I'm sure that this will all start to come to light as we see case law. Accordingly, however, any proposed monitor will want to satisfy themselves that there is a deliverable plan in place for the rescue of the company as a going concern, rather than the moratorium process being used on a speculative basis in the hope that the directors might find a solution with the benefit of time. The requirement that a rescue of the company rather than the business as a going concern is likely will mean that the moratorium cannot be used to stabilise a company's position in preparation for a sale of the business, whether through a pre-pack admin or otherwise. Companies already subject to an insolvency procedure and those that have been in a moratorium, CVA or admin in the previous 12 months are not eligible. Companies which are excluded from the moratorium are listed at Schedule 1 of the Act, and those include, for example, insurance companies and banks, etc. For the next month, now that the Act is in place, there are some changes to the eligibility criteria. The first one is the requirement that the monitor is of the view that it is likely that a moratorium would result in the rescue of the company as a going concern has been relaxed slightly for this first month, so that the monitor must only be of the view that a rescue would be possible were it not for any worsening of the financial position of the company for reasons relating to coronavirus. A company will be eligible for a moratorium even if it was subject to a prior moratorium or administration or CVA in the previous 12 months. And a further change is there is an additional exclusion from eligibility. Certain regulated companies which may hold money for clients will not be eligible for moratorium during this period. Okay, so I have just covered, in the next slide, who is excluded, and then now I will cover off what the process is itself. So there are two ways that a company can enter a moratorium. First one is the directors filing relevant documents at court, therefore being known as the out-of-court process, which is very similar to the current process for appointing administrators out of court, but unlike that process, no prior notice is required to be given to a floating charge holder before directors file. The out-of-court process will usually only be available to a company if it is not subject to an outstanding winding up petition and is not an overseas company. But to make the procedure more accessible to companies dealing with the COVID-19 situation, companies which are not overseas companies but are subject to a winding up petition will be able to use this out-of-court process for the next month only. By the directors, they can also make an application to court, so now known as the in-court process, and there are two circumstances where, in ordinary circumstances, the directors of a company may use the in-court process, and that's where there is an outstanding winding up petition or where the company is an overseas company. However, as I've just noted, for the first month, where there is a winding up petition in place, they will still be able to use the out-of-court process. The documents that need to be filed for the out-of-court process, and that will include an application for the in-court process, are the same. They include statements from the directors that they wish to obtain a moratorium and that they are of the view that the company is or is likely to become unable to pay its debts, and a statement from the monitor that they are qualified and consent to act, and that the company is an eligible company, and that in the monitor's view, it is likely that the moratorium will result in the rescue of the company as a going concern. So when does the moratorium itself become effective? Where the out-of-court process is followed, the moratorium commences when the relevant documents are filed at court. When the in-court process is followed, the moratorium commences when the court order is made. The directors must then notify the monitor, who must then send a notice to all known creditors and also Companies House. Therefore, it will be a matter of public record that a company has entered into the moratorium process. During a moratorium, creditors and shareholders are restricted from commencing an insolvency process. The directors may still put the company into a process and voluntary liquidation if is possible, if recommended by the directors itself. During a moratorium, there are a few things that cannot happen, one of which is a landlord cannot exercise its right of forfeiture. There can be no enforcement of security. There can be no repossession of goods under a HP agreement or exercise of a retention of title clause, and no legal proceedings or legal process may be raised, carried out, or continued, in each case without the permission of the court. Unlike administration, there's no provision whereby the monitor can grant his consent to such proceedings during the moratorium itself. In addition, during a moratorium, the holder of an uncrystallised floating charge on the property of the company is prohibited from giving notice which would either have the effect of A, causing the floating charge to crystallise, or B, restricting the disposal of property of the company. This is to allow the business to continue to trade normally during the moratorium itself. Restrictions on a company in a moratorium. So during a moratorium, there are various restrictions that are imposed on the company. I'm not going to go into the detail of all of them, but they are such that obtaining credit of more than £500, And that can happen if the creditor has been informed that the company is in a moratorium itself. In terms of granting security, security may only be granted if the monitor consents to the actual granting of that security, and consent can only be provided if the monitor thinks that the grant of security will support the rescue of the company. Duration of the moratorium. The initial period of the moratorium, as I've already mentioned, is 20 business days, which is a very short period of time for a company to negotiate and be ready to implement a substantive restructuring. Therefore, we do expect the vast majority of moratoriums to be extended, and in practice, given the ease by which the directors can actually extend the moratorium, we do expect that many will last at least probably 40 business days. But again, as Michael said, we'll have to see how this plays out. The moratorium, as I have already mentioned, can be terminated, and a monitor must terminate the moratorium if they think that A, the moratorium is no longer likely to result in the rescue of the company as a going concern, or the objective of rescuing the company as a going concern has been achieved. As a result of the failure of the directors to provide information regarding the company, and that information has been requested by the monitor itself, the monitor is unable to carry out its functions, or the company is unable to pay any moratorium debts or pre-moratorium debts which the company does not have a payment holiday, which, as I've discussed before, includes any sums owed to lenders. In addition, a moratorium will come to an end if the company enters into another insolvency process, if a restructuring plan or scheme of arrangement is sanctioned, if the court orders it to be so, or automatically upon the expiry of the moratorium term. So there is a detailed process for extending a moratorium. So as we talked about, the directors can extend the initial 20 business day moratorium for a further 20 business days after the initial period ends. There is extension by directors with creditor consent. The maximum period is actually 364 days, which includes the initial 20 business day period. And there is no maximum extension period at all placed with the consent from the court itself. No extensions, however, can be sought within the first 15 business days of the moratorium. Therefore, if the directors do not wish to avail themselves of the 20 business day extension without consent, that does only leave them with 5 business days for either an application to be made to court and be heard, or for creditor consent to be obtained and the filing to be made at court. Therefore, we do expect, in most cases where an extension is required, they will do that, as I've stated just earlier, without consent, and use the second 20 business days to secure a further extension if needed. There are particular rules also relating to extensions of the moratorium where the company subsequently enters into another insolvency process. So where the directors make a CVA proposal, the moratorium is automatically extended until the CVA takes effect. Where the company applies for an order to convene meetings in respect of a scheme of arrangement or a restructuring plan, which we'll discuss later, the court has discretion to grant an order to extend the moratorium. So that finishes when does it start and how does it end. I'll now cover off the status and role of the monitor. So as I've mentioned before, the monitor must be a licensed insolvency practitioner, and their role is to ensure the conditions for the moratorium to be in place continue to be met and protect the creditor's interests. The monitor's purpose is to monitor the company's affairs for the purposes of forming a view as to whether it remains likely that the moratorium will result in the rescue of the company as a going concern. As I've noted, the monitor's consent is required for the directors to undertake certain transactions. Otherwise, the day-to-day running of the business of the company remains with the directors, therefore making the moratorium a debtor in possession process and not the director-led process. The monitor must terminate the moratorium in certain circumstances as described earlier. Right to challenge. The Act does provide for the right to challenge the monitors or the director's actions, decisions or failure to act on the grounds of actual or prospective harm, unfair harm to the applicant. And there's also a right for a subsequently appointed administrator or liquidator to challenge the monitor's remuneration. The Act creates new offences of fraud during or in anticipation of a moratorium and false representation to obtain a moratorium. But again, as Michael discussed earlier, we will have to see how all of this plays out, as I'm sure it will do in case law over the next 6 to 12 months. And that's the moratorium covered.
Thank you. So looking now at one of the permanent changes that has been brought about by the Act is the prohibition of termination clauses invoked on entering an insolvency process. So looking at the provisions here, these aren't necessarily COVID-19 related. The inclusion of this has been fast-tracked to assist companies facing financial difficulties for whatever reason at the moment. And what it essentially does is inserts section 233B into the Insolvency Act 1986 and applies to all relevant insolvency proceedings, including administration, liquidation and the new moratorium. The scope of the new section 233B is broad. Not only does it nullify the supplier's right to terminate a contract, but it also precludes them and prevents them from doing any other thing. And what any other thing may mean is amending terms of supply or amending any payment terms, just because the company has entered into a relevant insolvency procedure. The change relates to all contracts for goods and services, and upon a company entering into an insolvency process, it will suspend the supplier's right to terminate for a pre-existing right. So if there was something going on pre-insolvency or pre-insolvency event, then the supplier is no longer able to rely upon that condition. There are things in place to consider this from a supplier perspective, so there are safeguards and exceptions there. One way in which a termination clause can still apply is if the company consents to the termination. Another way is seeking the court's permission that the termination clause be relied upon. For this to happen, the court must be satisfied that to continue the supply would suffer hardship. The Department for Business, Energy and Industrial Strategy sets the hardship bar at a high level. The example given is where the supplier's own solvency would be affected by their continuation to supply. Although this is a permanent inclusion into legislation, there is a temporary exclusion to run until the end of this month, which gives small suppliers the right to continue to terminate contracts. The effect of this could mean going forward that there may be a risk of suppliers withdrawing goods and services earlier if at the first risk of any sign of financial distress of any of their customers, they may seek to get out of the contract before any insolvency proceedings are on foot. It may also lead to changes in the way that new contracts are negotiated and where termination clauses are looked at.
Yeah, thank you. Okay, so this part of the Act is huge, and this is the part that I think the act of the monitor in terms of putting together the restructuring plans will hugely be called into question, because as you can see, there's some fancy phrases that appear here: senior creditor cram up, cross-class cram down. So there are going to be a lot of disenfranchised parties within this process. But I do really like the actual thought behind the restructuring plan itself. As we know, there are presently 2 statutory mechanisms for a company to reach a compromise or arrangement with its creditors. So we've obviously got scheme of arrangements and we've got CVAs. CVAs generally used by companies looking to restructure, but they cannot affect the rights of secured creditors or preferential creditors without their consent. Scheme of arrangement has in the past been extremely highly regarded and has proved to be a flexible tool, especially in the recent years. However, it's always fallen a little bit short of our US counterpart, and this restructuring plan they hope will be and provide more of a complete solution for companies in distress. So without going into too much detail in today's webinar, and obviously as Michael said, we can have conversations offline. The new restructuring plan itself, the procedure is intended to broadly follow a very similar process for the scheme of arrangements, which is the approval by creditors sanctioned by the court. But it will also include the ability for a company to bind particular classes of creditors and, if appropriate, members to a plan even where they've not voted in favour of it, and that's known as the cross-class cram down, and that's obviously where you're going to get some disenfranchised parties. Cross-class cram down must be sanctioned by the court and will be subject to meeting certain conditions. As long as the eligibility criteria for the new moratorium have been met, it will be available to use whilst the company develops a restructuring plan, allowing it to do so free from enforcement action, as I previously discussed, and providing them therefore with a streamlined restructuring process. As we know, creditors and sometimes members are divided into classes based on the similarity of their legal rights, which can vary significantly across a company's creditor base. And each class must vote on the proposed scheme. If all classes vote in favour of the scheme, requiring 75% by value and a majority by number of each class, the court must then decide whether to sanction it. Not all creditors or members of a company need to be included within a scheme. A company may organise a scheme in such a way as to exclude some creditors or members from it. Those creditors or members who are not bound by the scheme retain their existing rights. In order to exclude a class in this way, however, they do need to demonstrate that that class has no genuine economic interest in the company. So what is the effect of this? So the effect is a restructuring plan confirmed by the court will be binding on all affected parties. Parties' rights following confirmation of a restructuring plan will be as provided for in the plan itself. Any previous rights will be extinguished by the plan being confirmed by the court. Therefore, interestingly, if a company enters into an insolvency procedure following the failure of a restructuring plan, the rights and claims of any creditors bound by the failed plan would be as under the plan itself. As I mentioned at the start of talking about the restructuring plan, this is where you are going to get disenfranchised parties, and therefore the whole aim of the restructuring plan and ultimately the approval of the plan will be in the court's discretion, and it's therefore likely that the court will need to develop a test of fairness to address the type of situation where we are talking about dissenting classes being forced to accept restructuring plans against their wishes. Senior creditor cram-ups. Whilst much of the focus has been talking about cross-class cram-downs, there will be situations where it will be possible to use a restructuring plan to cram up senior creditors. In most cases and in most situations, it's going to be necessary to involve any senior secured creditors in the formulation of and support the restructuring plan. As we've talked about before, they will obviously have been involved in the moratorium process. But there can be some senior lenders that can be in very different positions. So, for example, where there is an intercreditor agreement in place, and there's a senior secured class, and therefore they might not have the defence of any security enforcement available to them. So where a senior creditor cram-up is contemplated, there will be complexities and lots of matters need to be taken into consideration, with the focus again being on the overall fairness of the proposed restructuring. And none of this is going to be straightforward, and I've no doubt that the plans itself and the test of fairness will no doubt lead to substantial litigation. In my view, the introduction of this new restructuring plan will bring about a fundamental change to the way companies and creditors approach many distress situations. Like I say, it's going to be a level of uncertainty as to how the courts are going to develop these principles of class and fairness under the new regime, and how they will address the complex issues that they are going to inevitably face.
So just to recap then on the purpose of the bill and now the Act being brought into force, it really is to give some flexibility to meet the demands of the various demands that the businesses are facing at the moment in the COVID-19 crisis. We touched upon the legislation introducing both permanent and temporary reforms. We've already touched on some of the permanent measures that are now in place in respect of company moratoriums, restructuring plans, and the prohibition of insolvency termination clauses. What we'll go on to look at now are some of the temporary reforms that are in place, suspension of the director wrongful trading offence, and also restriction on service of statutory demands and presentation of winding up petitions. So first of all then, looking at the temporary removal of the threat for personal liability for wrongful trading. What we are dealing with here is the failing of a director in their duty to take every step to minimise potential loss to companies' creditors, where they know or ought to have known that there is no real prospect of the company avoiding insolvency. What this is helping directors to do is deal with trading their businesses through uncertain times, and affords them some relief in doing so, as it removes the threat of personal liability. So I think the hope here is that companies are more likely to trade through this period rather than seek to go insolvent to avoid this liability. It's important to note here that when the court is faced with any question of director's liability during this period, the assumption is that the person in question is not responsible for the financial worsening of the financial position of the company or its creditors. We've looked at the relevant period so far, and as much as the new measures are going to be in place until the 30th of June or 30 days following the enactment of the legislation. So we're looking at the 30th of July now, where the courts are looking at this again is applying it with retrospective effect. So they will apply this going back to the 1st of March, and that is likely to go until the end of July now. It's important for directors to remember that these exclusions only go so far. The relief afforded to directors is limited. It is still incumbent upon directors to ensure compliance with their other duties, fiduciary duties, statutory duties, and I can imagine that there will be some questions raised over this, where perhaps there's investigations into use of current government funding, such as furlough. These are all things which I don't envisage will be covered by this. So moving on then, looking at the petition position with winding up petitions at the moment. Again, this is a temporary measure, and it seeks to restrict the presentation of a winding up petition, and the key date for this is the 27th of April 2020, whereby a creditor is unable to present a petition which is reliant upon demand that has been served within the relevant period, i.e. from the 1st of March. Ordinarily, a creditor will be able to present the petition or rely upon an unfulfilled statutory demand, but at present, where it has to be the assumption that all debts are related to coronavirus and the current pandemic, creditors are no longer able to simply rely on a debtor being unable to pay their debts. Should a creditor believe that the indebtedness to them is not coronavirus related, they are able to rely upon the coronavirus condition. Now, this is something which needs to be stated within the petition itself, and essentially what they're going to have to demonstrate to the courts is that coronavirus had no financial impact, or that the facts that have given rise to the petition would have arisen even if coronavirus had no financial effect. This, I think, is going to be difficult for creditors to prove to the courts. It's largely going to be a matter of evidence. There is going to be a considerable amount of disclosure, and from a litigation point of view, I believe that there's tribal issues there. Again, we need to see how this will play out. There are some cases that have gone through the courts already where this has had retrospective effect, and we'll come on to those later. Again, important to note that the courts will apply this retrospectively now for petitions going through the courts at the moment. Moving on then, we mentioned at the beginning of the webinar that there are certain amounts of flexibility being given to various meetings to be held by companies at the moment. These include the extension of the period to hold the AGMs, meetings to be held virtually. Won't deal with that in any great detail here, but there is full guidance available on that if that's useful. And again, hard deadlines for filings at Companies House as well. I think a lot of companies are finding these current conditions quite challenging. It's the first time that a lot of businesses will have had to work from home, will have had to furlough staff. All of these things, the relaxation of deadlines and amendments to company regulation is really just an attempt in the legislation to support companies in trading through this. We've talked about the retrospective application of some of the temporary measures. Now, whilst the bill has been going through Parliament, the various discussion stages, as we said, it was given royal assent at the end of last week and has been enforced from the 26th. The courts have been giving consideration to it, and there will be retrospective application of it given going forward, and specifically looking at liability for wrongful trading, provisions surrounding statutory demands, winding up petitions, and as I've just mentioned, the AGMs and other meetings to be held by companies, and also filing requirements as well. As I mentioned just before, we've had a couple of cases that have been before the courts already, where the bill in its draft form has been considered, and also other circumstances surrounding the COVID-19 outbreak. This particular instance involved a landlord pursuing a tenant and trying to make them insolvent. The judge could see in this case that Travelodge was able to demonstrate that its business was in a relatively healthy state. During lockdown restrictions, revenue of Travelodge is said to have dropped by 95%. This was enough to convince the court that Travelodge fell within the category of tenants that the government was seeking to protect through the proposed changes to the law. Travelodge were also able to demonstrate that it had a workable turnaround plan in place, and by doing this, the court looked at the bigger picture and considered that Travelodge trading through the current situation would be more beneficial to the landlord than allowing the winding up to take place when it was before the courts recently. Another situation involving a landlord and tenant can be seen in this, the matter of Gardens LLP. This didn't go in Gardens' favour. It's another instance where it involved landlord and tenant. The court weren't satisfied that the failings to pay debts were solely due to coronavirus. The judge did say he understood that the intention of the bill and how it applied to landlord and tenant situations, but the petitions that led to this matter being before the court were presented well before the 27th of April, and the arrears that it was based upon were long-standing arrears and also cost orders. The court felt that due to the length of time that the money had been outstanding, the bill and latterly the Act wasn't engaged, and despite the widening of its scope, this petition was granted. The next case that we've seen go through at the moment was a company. This is a matter that related to a high street retailer which had been financially impacted by COVID-19, and the court was satisfied that there was a strong case at its lowest that it had been impacted by COVID-19. Where we looked for the coronavirus condition, where a creditor is able to say and demonstrate that debts fell due weren't as a result of coronavirus. This is a clear example of that inaction, that the creditor simply wasn't able to dispel the presumption that it was a coronavirus related situation. the court was keen to emphasise in its decision that it was supported by the policy objectives that were surrounding the bill coming into force. So in this instance, the company was protected, and it was clearly to be expected that cash flow will be impacted as a result of lockdown. Okay, that's the case studies done. I think we've got some time now for some questions.
The question that we did have, which I do think I covered off earlier anyway, was how will people know that a company has been placed into the standalone moratorium? So obviously, as we've just explained earlier, there will need to be a filing made at Companies House, and notification of the moratorium will need to be sent to creditors as well. So that was one question that we'd had in earlier. And apologies, Gabs did show me another one as well, which was talking about directors.
Yeah.
And the ability to question a director's actions. And again, as I covered before, which we both spoke about earlier, we think that this is where there will be a vast amount of litigation and things to flow as a result of this, in terms of the monitor's actions, but also the director's actions in the moratorium period, especially if, as I mentioned before, with creditors' consent, that could be up to 364 days. There's obviously going to be some acts that will be taken out in that time period that may be called into question. So yeah, certainly there will be a procedure in place to question the actions of all concerned.
Okay. Right, well, we've had no other questions in this afternoon. As I said at the start, you've got our contact details there. There is loads more detail that we can give in relation to any of the aspects that we've spoken about this afternoon. So please feel free to get in touch if you do have any more specific questions or scenarios to run through. We will be providing updates in due course as we see things happening in the courts and different things arising. So thank you very much.
Thank you.